I'm not exactly sure what counsel means about the government continuing to make decisions, but my colleague will be arguing the motion for discovery. I think we too think summary judgment is where this case should be headed on the record.
All right, well, there'll be time enough to discuss that. So let me ask, I want to make sure that I have the complete record at this point. I've received, obviously, briefs on both sides, very extensive filing of declarations, both individual declarations, organizational declarations, and expert declarations on the plaintiff side. What I have from the defense is the brief, and then, of course, the determinations that were made by Secretary Noem that are in the, I guess, in the Federal Register. And I assume you're asking me to take notice of those.
Yes, Your Honor.
But there are no sort of counter declarations, at least as we sit here today. Is that correct?
That's correct, Your Honor.
And the government is not seeking to introduce any evidence at today's hearing?
Not today, Your Honor.
Well, then let me ask, there are a lot of issues in dispute. We're going to talk about that, everything from jurisdiction and everything else and statutory interpretation. But just to get a couple things out of the way, I'm trying to figure out sort of what's not in dispute so we don't have to spend a lot of time on that. One is the claim of irreparable harm if postponement is not granted to the plaintiff and injury to the public interest. That's what many of the declarations are about. And so there are a number of declarations about specific harms that would befall folks who are now have the protection as beneficiaries under the TPS as was extended. Does the government take issue with the bona fides or the veracity of many of those declarations?
No, Your Honor, we do not.
Okay. And so, for instance, there's one of the declarations is from plaintiff MH and her 7-year-old daughter, who talks about the need to care for, she's caring for children and volunteering at a health clinic, but she needs a driver's license to drive her severely asthmatic son to the hospital, and there's a number of consequences that would befall. That representation is not being contested, at least at this point. Something like that. That's
correct, Your Honor. Not for the individual plaintiffs.
Okay.
I think that's what you're talking about. There are expert declarations as well.
All right, so let's confine ourselves first to the individual ones. Those are not challenged, at least at this juncture. Maybe a trial, there could be something else, but at least for today's purposes.
Correct, not for the purpose of today's motion.
Okay, so let's talk, then you mentioned about the expert declarations, and there are several. And the data that was presented by the expert declarations address, for instance, the high educational attainments of Venezuelan immigrants, including those who are here on TPS status, that appears to actually perhaps exceed that of the native population. Very high rate of, for instance, bachelor degrees held by those over 25 is actually higher than that of the general population. Is that contested? That kind of fact, or that fact in particular?
We don't contest the facts. We just don't think they are relevant to this motion and shouldn't be considered.
All right. So you don't contest, they contest the relevance, but not the fact of, for instance, high employment rates, which also show high employment rates and participation in the workforce that exceed that of the general population.
We don't have any counter facts, so we.
Okay. And perhaps relevant to one of the issues I do want to talk about is at least some indication that the crime rates among immigrants, including those from Venezuela, are actually on the whole lower than the general population. The incarceration rates, for instance. Do you have any reason to doubt that?
Not today, Your Honor. However, again, I don't think that those are relevant to the motion itself because we don't believe the court has jurisdiction to delve into the decisions.
Okay. They may be relevant, maybe not the jurisdiction, they may be relevant if we got past jurisdiction into balance of hardships and irreparable harm under the usual test that applies.
Correct. I think it can be analyzed for the balance of hardships.
Okay. And then we have general evidence, sort of general economic evidence about the potential loss to the U.S. economy. One, Professor Carr estimates a $3.5 billion annual loss in economic activity and an annual loss of over $400 million of Social Security taxes that are paid by TPS recipients from Venezuela. At least at this point, you don't have a counter affidavit.
Correct. I have no counter evidence to these affidavits at this point.
So, and then there is there's a finding, I think, by Secretary Nome of conditions improving in Venezuela as a country that sort of justify, at least on the termination side. I don't think that informed the vacator. Is there anything in the record other than what's in the Federal Register that I should be aware of? Any reports, any update reports from State Department or any agency of the federal government that is more specific, that explains what has improved in Venezuela?
Not today, Your Honor, just the Federal Register notices. And I think Secretary Mayorkas recognized that fact as well in his extension.
Okay.
But it would be a part of the administrative record.
Which
we don't have today.
Which we don't have. And I will say in advance, I mean, to kind of skip ahead a little bit, it does seem to me that in terms of discovery, what is now, I think, more clear than in the Ramos case is that I think the preference is to try to assemble and agree upon an administrative record as a first step, and then determine whether or not the step of going outside the record and supplementation is appropriate, because it may be that the record has much of what the plaintiffs might want or need. I don't know at this point. I think we're all sort of curious what's in the administrative record since this happened so quickly. I think the first action, the vacator, took place within days of Secretary Nome assuming office after her confirmation. So I don't know what the record looks like, but I think that's something that you all should work out as a first step. So I will indicate that with respect to discovery, I do think it's now more evident and clear from the case law that the first step is try to identify the administrative record as a basis. And just the last point, this fair amount is made about the Trends de Aragua, the TDA, which is the name given to alleged gang members from Venezuela. Do we know if there's anything, again, in the record that I should be aware of that shows that counters, for instance, that there isn't a declaration from Mr. Dudley, I think, that the plaintiffs have submitted, who looks at the crime reports and concludes that the TDA is not currently a major threat in the U.S. and they have no substantial presence. Is there anything in the record that I should be aware of at this point beyond what I saw in the Federal Register that substantiates the extent of TDA's criminality and presence in the United States?
Again, just the notice and then the footnotes that cite to some of the documents that Secretary Nome relied upon.
And in those documents, is there hard data? Is there actual data about, for instance, how many members there are estimated? What is their current criminal status now? Obviously, there's been a recent deportation, which has been the subject of another matter in another court. But is there any data at all in the record?
I'm not aware of that right now. I don't have a specific answer to that.
Okay. All right. Well, so it appears that at least for purposes of the motion under 705, which although it is not a motion for injunction under Rule 65, that I think everybody agrees that the same factors, the winner's test and everything else sort of applies here. And I am to look at whether there's irreparable evidence of irreparable injury, balance hardships, which may inform the degree of the merits showing. And why don't we just address that for a moment? I mean, it does seem to me that given the affidavits that are, at least at this point, uncontested, And taking into account there were two amicus briefs filed by a number of states, as well as another one filed by cities that sort of address the impact on their economy, the impact on public health and public safety, the adverse impact, the loss of TPS status, and the loss of folks' ability to work and drive, et cetera, would have. It seems to me that the requisite showing of a likelihood of irreparable injury in the absence of relief is pretty clear, at least based on this record. It may be that at trial we may see something else, but so far that element seems to be not in dispute, but maybe I'm wrong. You can correct me.
Yes, Your Honor. We don't concede irreparable harm here. We note, as we said in the briefs, that temporary protected status is temporary, and the harms here are inherent to the status itself. So as a legal matter, while these are difficult choices, which we recognize there are difficult choices, but as a legal matter, this was always the outcome of temporary protected status ending.
Right. I understand that legal argument. I think that argument was addressed in the earlier Ramos case, and I think as I held that although obviously things like, for instance, family separation and mixed family situation, having to return back to a country with adverse conditions, et cetera, perhaps is inherent in the temporary status, but time matters, and that the time, for instance, with family, it seems to me it makes a difference if you've got, 30 days as opposed to 3, 4, 5, 6 months, 7 months, 8 months. Time matters. I mean, I take it that's the plaintiff's position as well.
Your Honor, our position is that the legal position is that they're entitled to the extension from January 17th to run through October 2026. And that's also, you may recall from Ramos, our position is that the relevant determination is whether country conditions are such that is now safe for the return of its nationals. So that's a determination that would have to be made at some point after a couple of months, 60 days-ish, before October 2026. And our view is that the plaintiffs are entitled to rely on that. And the last thing I would say on this subject is the bridge in time may allow a number of people in this community to obtain forms of permanent relief. Freddie Rivas, for example, has enabled one of the plaintiffs with H-1B sponsorship opportunity. He can't get it if he falls out of status. A number of these individuals have applied for asylum. There's a huge asylum backlog. Some of them may have their cases get through in that period of time, and there's a number of other ways that so it absolutely matters, even if we're just talking about a few months, and all we're talking about is through October 2026. That absolutely matters. But also, it's beyond that for many of these people. It means that they have an opportunity to avoid going back to the country and massive stress for much longer.
All right, so you're saying there are potentially two consequences. One is the time element, that is time with family, time to be able to work, time to, whether it's, separation that's early by months or days, time matters. And you're saying that there are, for some folks, it's more than just a temporary, the additional time with family and in the community, it may affect their actual more long-term status because they have various applications that are pending that would be jeopardized if the TPS protection were to disappear quickly. And then I do have to look at the balance of hardships, as I mentioned, and that's why I was sort of asking some questions. I can hear and see what it is on the side of the, how many Venezuelan TPS beneficiaries are we talking about it being affected at this point?
50,000 in the
Excuse me, counsel, can you speak into the record? They're having a problem hearing.
Microphone, yeah.
Excuse me, microphone.
There's 350,000 in the April cohort. And by the way, that's what Professor Card's analysis is just about those, the 3.5 billion and 400 and something million of Social Security. It's just about those. There's another something like 240,000 who would lose their right to live and work here in September. So the total number, I believe the estimate was 607,000 overall. So it's actually larger than the entire Ramos and Bacay population, this population of people. It's a huge, huge population of people.
All right. So the hardship to the government if a postponement were granted, obviously you've made the argument that the inability to carry out orders is sort of inherent in any sort of stay or postponement. What else? Is there anything else? There's some reference made to public costs I don't know if these are costs that are incurred by local and state governments in terms of support services to this population. I don't know if I saw any quantification of that, but maybe you can articulate what are the harms to the government if postponement were granted.
If I could go back to the numbers and to your point of time.
Yeah.
The September deadline one has not been terminated as of yet. I can't speak to what is happening with that. I don't want to intimate that I have any knowledge as to what's happening with that end date, but I do think that's exactly what plaintiffs are asking for, is more time, right, to prepare to return. So I don't think that the harm of the 240 should be considered in this postponement.
The 240, these are the folks that would be affected
with the end date of September 10th, I believe.
What's your response to that?
Right?
What's at stake for them is, do they lose the right to live and work here on September 10th, 2025, or instead in October of 2026, and even then only if there is a termination that comes at the end of that period, which is what we believe they're entitled to. And that period, just from now till September, Your Honor, is about the same time that was the time period from when we started Ramos until the Sudan termination. So that's still a very short period. It just feels longer because there's 350,000 people whose deadline is coming up in 2 weeks, or less than that now. So it seems clear to me that that set of people can also have their harms considered. I mean, they have to make plans now about whether, without knowing whether their extension will go on beyond September, whereas what they thought before was that they were entitled to TPS for more than another year beyond that, 13 months beyond that.
So it's sort of the difference between 6 more months versus about 18 months?
Exactly, Your Honor.
Okay. So it's slightly less of a difference, but still a significant difference, about a 12-month difference.
Yes,
13-month difference. All right, so go ahead. Tell me about the harms to the government.
And I think, as Your Honor noted, right, the harms to the government are that the Secretary has looked at the issue, has made a determination related to the national interest, and the Secretary has an interest in having her orders carried out.
Okay, so other than the interest in having her orders carried out, and of course that begs the question whether her orders are lawful, because if they're not lawful, there's much less of an interest in carrying out an unlawful order. But if they're lawful, then there's a strong interest in the government being able to carry out its lawful orders.
Correct, Your Honor.
So it sort of begs the question a little. Is there anything else in terms of economics, safety, et cetera, that the government is asserting as a counterbalance in terms of the balance of hardships?
Just the language in the termination notice itself, Your Honor.
And the thing that I remember seeing there, there's a fair amount of emphasis on the TDA as public safety.
Sorry, I didn't mean to.
Go ahead.
There's a focus on the TDA. There's a focus on communities. There was a statistic on the effect of individuals in various cities. I think New York was used as the example of the effect. If you look on in the February 5th FRN page 9043, The notice states, for example, over 180,000 illegal aliens have settled in New York City, approximating that this will cost the city $10.6 billion through the summer of 2025. So all of that information in the Federal Register notice goes to the balance in favor of the government.
Right. What's the plaintiff's response to something like that?
Well, Your Honor, that's about what happens when a set of people first come before they have employment authorization. So I think the question, this is a mistake that runs throughout the termination decision. The TPS doesn't let anybody stay, get here, enter the country. It just means that if you're here and you qualify, you can get work authorization and be allowed to remain. And so the point that's made, I believe it's in the Voiger Declaration, I think it's in the Voiger Declaration, certainly in the amicus briefs, is that what we're talking about now is really to strip all these people of their employment authorization. So obviously, if you take away people's right to work, that worsens the burden on, just sort of every aspect of the public sector.
So what's critical is to take this photo take the snapshot at the right point in time. And the point in time is now when we're talking about removing authority and protection from folks who are already working for the most part.
Exactly, Your Honor.
And I thought I saw a statistic that said that the income of Venezuelan TPS recipients is something like 96% earned income.
That's correct, Your Honor. The amount of public assistance now, on average per person, it's less than $200 per year or something like that. There's different numbers about labor force participation, but they're all extraordinarily high, like 70%, 80%, depending on which economist that you talk to. And obviously, that's in a world where they have employment authorization. You take that away, all of that will become worse. So the fact that they say that, in 2023, there were burdens placed on cities like New York and other cities when this population came in and didn't yet have employment authorization is just irrelevant to the question of now, if you take it away, will that make things better or worse?
Okay, well, what's the government's response to that? If you take it from the snapshot in time of where that population that may be affected by this action is largely an employed population and with little dependence on public assistance.
The idea behind ending the temporary protected status is that the individuals that they can return to their country. And so it shouldn't be that these individuals who are working with lawful status and lawful employment authorization documents now seek public assistance from the states where they're living. So I don't think that is a correct comparator.
Well, what we're trying to measure is what harm would befall the government if the injunction, or not injunction, but the postponement were to stay in place. If there's ongoing taxing of the welfare system, for instance, then it's something to consider in terms of the fisc, the public fisc. But at least what I'm seeing from the evidence that's in this record so far is that there's not much of a burden on the public fisc at this juncture. Maybe it was some years ago when folks first got here, but it appears that the employment rate and market and labor force participation is very high for Venezuelans.
And as I've stated, I don't have any contrary statistics on those numbers.
Okay. Well, thank you. Let's talk about some of the key issues here, because it may be that all this goes nowhere, depending if I have jurisdiction, which is the first question. And there are two jurisdictional issues. The first is the limit on injunctive relief under 1252F1. So the question in that context is, does it apply here or does it not? And there's a couple of issues. Let's get the
Your Honor, may I speak from the lectern?
Yeah.
Why don't you come on up, opposing counsel?
Lectern, and let's talk about 1252, which is subsection F is entitled Limit on Injunctive Relief, so it expressly uses the term injunctive relief, and it refers to the lack of jurisdiction other than the Supreme Court to enjoin or restrain the operation of the provisions of Part 4 of this subchapter. And Part 4 of the subchapter, the statute in question does not fall under Part 4 right now. It's codified under Part 5, as I understand. Is that correct?
Your Honor, we have litigated this under the postponement motion without delving deeply into the question whether the TPS statute is under 1252F. So I guess we're not pressing the argument that it's not within it, because we think that we can get a postponement and preservation of the rights under the APA, irrespective of whether the TPS statute is part of Part 4 of Chapter 2 of IRA or not. Strangely, it seems that there's actually disagreement on exactly what the scope is of those words. There's Ninth Circuit law, which said everybody thought that the TVPRA was within it, and then the Ninth Circuit said it was not. And so, we looked at this and wondered whether or not we should litigate that question in this motion, and thought the simplest, narrowest way, particularly given that we've got a deadline of April, was to argue that a postponement is not a vacatur and doesn't fall within 1252F. That's what the Fifth Circuit held. It's what every court to consider the question has held. So we thought that was a way to get the relief that we sought without delving into this strangely ambiguous question of what is within the scope of that code provision.
All right, so you're sort of reserving that point.
Yes, Your Honor.
And at least arguing whether the terms of F1 really apply to this situation.
That's
So
right.
what is the difference between an injunction and a vacator or a postponement?
I think the core difference is that the postponement and also a set aside or a vacatur under the APA operates directly on the agency action, and it does not, by its terms, enjoin persons or federal officials in this case. And so, Your Honor, if you were to rule in our favor and postpone the effective date of the vacatur and the termination, you would be robbing them of legal force, at least on a temporary basis. It would be like wiping them from the books for the time period. That order does not itself direct any federal official to do or not do anything. I acknowledge that that can feel somewhat formal in a way, because the bottom line is that everyone, if you rule in our favor, everybody would have employment authorization and would still have the right to remain in the United States. But the doctrine on this subject has been extremely focused on the form and not just on the substance. If you look at the Supreme Court's decision in Chen, for example, where they said stays of removal are not within 1252F2, a lot of the law. Look at the Fifth Circuit's decision in Texas on this exact question that we're talking about today. They're very focused on the fact that the order runs against the rule and not against the officials, and that seems to really matter when it comes to how the doctrine thinks about remedies in this context.
Why should that make a difference whether you're restraining the agency in name or a person that directs the agency?
I think the immediate answer to that question is that if there is a violation of the court's order to postpone, there's no person who is immediately subject to contempt. And that's the kind of sort of operational difference in the immediate term. It's similar to declaratory relief. If you violate a declaratory relief order, if a defendant violates a declaratory relief order, it doesn't immediately subject them to contempt. Of course, then you could have a motion to enforce, and if that motion to enforce happened and then the court issued an order, then Obviously, contempt sanctions could run for a violation of the court's order. But that
How does a person get involved, you say, in the motion to enforce? At that point, then you name a particular individual that's charged with enforcement?
That's right, Your Honor. And that would be an individual that hypothetically would be violating the court's order because they're treating the agency action as still in effect when this court had ruled that it was no longer in effect.
So that extra layer of having to bring a motion to enforce and then name an individual before contempt can be held makes it one step removed and less intrusive. Is that the idea?
Yes, Your Honor. So exactly, the Monsanto, the Supreme Court case in Monsanto says that vacatur is a lesser form or less, something like that, less intrusive, less coercive in some way. And if you look at Chen, again, the Nken v. Holder, which is the case about a very analogous question. It's about whether a stay of removal, like a removal order to deport someone, is injunctive or not. That's the reasoning that the court uses there. And this is what I'm now explaining is also the reasoning of the Fifth Circuit in the Texas v. U.S. case. And several different district courts that we cite, the Kidd case in the Central District of California. There's a case in Florida. A number of district courts have said this.
Is there contrary authority?
On 1252F specifically, we are not aware of any contrary authority, and they haven't cited any. And additionally, Your Honor, I would say this idea that APA relief in general operates directly on the rule, that's also the reason why that relief applies as a default rule, applies what they say universally, and that if Chevron brings a lawsuit against the Clean Power program and they win that the Clean Power plan is ultra vires of the statute, Texaco doesn't need to also bring a suit in order to stop it as applying to them. It just operates against the rule. That same reasoning, which is the reasoning we're talking about now for 1252F, that applies to the APA writ large. And that idea that an APA vacatur normally operates against the rule is the holding of the Ninth Circuit in East Bay Sanctuary. That case was citing the Regents case from the Ninth Circuit. And there are a mountain of APA cases in every circuit that say this. It's the DC Circuit's practice going back at least into the 1980s. And that's why the default rule in APA cases is that the rule applies against the rule itself. And they haven't explained why you could somehow carve out 1252F and say that rule doesn't apply here, but still preserve it in all of the APA. And if you look at their briefing on this subject, they're saying essentially, they're pointing to some case from the 1970s, which cites some case in the 1930s about the APA's legislative history. They're trying to basically undo these decades and decades of APA doctrine on this subject. So, they're entitled to make that argument. Maybe in the Supreme Court, I actually think the Chief Justice thinks this is wrong. The DC Circuit Justices think this is wrong. But whether or not they ultimately get there, for today, for purposes of this court, what they're asking for is a revolution in the APA jurisprudence, and that's not appropriate here. The normal rule applies. This is a postponement. It's just a temporary form of what would be a set-aside, which is APA relief under Section 706, and that relief is not an injunction. It's not an injunction. It operates directly against the rule. It doesn't apply to persons, and that has been the practice of the federal courts on the subject going back for decades.
What would be an example of where the prohibition or the bar of 1252F1 would apply in the APA context? It would have an effect of restraining a court injunction.
Well, prior to the Aleman Gonzalez decision, which that decision is 2022, I think. It's after Ramos anyway. Before that, courts issued injunctions, and they weren't, in my view, particularly cognizant of this distinction that we're spending all this time talking about now. So, for example, when we were here on the preliminary injunction in Ramos, we sought an injunction, and we didn't sort of think much of it. Are we seeking a vacatur, a set-aside, or are we seeking an injunction? We weren't cognizant of that distinction. I think now, after Aleman Gonzalez, if we sought an injunction, then Your Honor would have to address this question that you started with, which is, is the TPS statute within the confines of 1252F or not? Because an injunction, let's assume that it were, okay, if it were, or let's say this case was Aleman Gonzalez and we were seeking relief under the detention statutes, well, then the order would violate 1252F. So you couldn't, if you issued an injunction, and you actually wrote it that way. So this is an injunction. Every officer of the DHS is enjoined from, whatever it may be, from deporting anybody who has TPS, from taking away their employment authorization. Assuming
but I wouldn't have to. I mean, your view is that relief could be sought under the APA 705 and 706. So what I'm asking is there a place where 1252F4 would actually, not because some judge issued it and used the word injunction, but because actually that you couldn't get relief under 705, 706? Or are you saying that it's always proper to seek relief under 705, 706, and therefore you're free of 1252?
Now I understand your question, Your Honor. Yes, there are many times in the immigration context where one might bring litigation not to challenge agency action, but instead to challenge other things. You might challenge the statute itself and not the way it's manifested in agency regulation. And then you couldn't bring a claim under the APA. If we argued that a statute was unconstitutional, and we might have other arguments, like maybe it doesn't apply to constitutional claims or something like that, but that would be outside the scope of the APA. That lots of immigration cases that I've litigated, that lots of people have litigated, were not APA claims. They were claims under whatever statute or claims under the Constitution. And for all of those, APA relief is not available. And then, 1252F may bar it. So in Aleman Gonzalez, for example, the claim was that this Constitution requires that the set of people subject to prolonged detention are entitled to bond hearings, and that the statute authorizes it. Not that the APA was violated in any way, but the statute actually requires that the set of people subject to prolonged detention receive bond hearings. And we brought that claim. I was counsel among the counsel in Aleman Gonzalez. We brought that claim under the immigration laws and under the due process clause. And the court said, you cannot get an injunction. They didn't address the constitutional question. They said, you cannot get an injunction under the immigration statute for this claim. So our claim today is not brought under the immigration laws as such. It's brought under the APA. Obviously, the constitutional claim is different. And so that's the reason why 705 relief is available to us.
So when 1252F1 refers to not being able to enjoin the operation of provisions of Part 4 of the subchapter, there are examples you can give me of Part 4 matters that might otherwise be subject to an injunction. I guess there's a lot of stuff here. It's inspections, apprehension, examination, exclusions, and removal. Are there examples of operations of any of these subsections, which is 1221 through 1232, that would otherwise be enjoinable but not enjoinable because of the bar of 1252F1?
Yes, Your Honor. So Aleman Gonzalez itself is a claim about how to interpret Section 1231A6. And we said that provision must be read to require bond hearings for people subject to detention. The government said no, they could be locked up even for years without a chance to ask an immigration judge for a release on bond. And the court said you cannot win an injunction requiring them to perform bond hearings under the statute. Okay. And the same could be true for other provisions involving detention, certainly 1226C, 1225B. It could also be true if you look at the Ninth Circuit's decision in Al Otro Lado. I can't remember if we cited that case in this context or not, but I think we did actually. But if we did not, we can submit it to this court. I mean, that's a decision where the court is looking at an injunction concerning certain aspects of the asylum rules, and they say parts of that court's order are outside of 1252F, and so they can be they can survive Alamán González, but other parts, which I think particularly concerns the ability for people to come back and apply for asylum again, they say that part is not exempt from 1252F, and you cannot get an injunction for that part. And there, they were not challenging. They had a separate challenge to the agency interpretation of the asylum statute, but the relief that they sought as a remedy was you have to let these people come back and give them another chance to apply under a proper understanding of the asylum rules. And the court said that form of relief is barred by 1252F. And there's no, I don't think that there's a way that you could say the APA, there's no APA error there. It's just, it's one form of relief that the plaintiffs asked for and that was not available because the only way to get it was via injunction.
So in other words, 1252F1 has operative effect, but outside of the area of an APA challenge under 705 and 706.
Yes, Your Honor, it does. The last thing I would say on this subject, Your Honor, the Supreme Court considered, they granted cert, actually, on the question whether APA relief is outside of 1252F. It's come up twice in Supreme Court cases. In Texas v. U.S., or in the Supreme Court it might be U.S. v. Texas, which is a case about the enforcement priorities. And just before that, in Biden v. Texas, which is a case about the Remain in Mexico program. And in both of those, the government was making a version of the argument that you're suggesting now, which is you're blowing a hole through the statute if you can sort of get around it because it doesn't apply to the APA. And in the dissent, I believe it's Justice Gorsuch's dissent in the U.S. v. Texas case, he makes a similar kind of point. But the Supreme Court reserved the question both times. They did not decide the issue, and they acknowledged it was difficult. And one of the justices of the Supreme Court, like the Chief Justice was making, was, well, if we accept this idea, then we have to just get rid of what the D.C. Circuit has done in APA cases going back forever. And since that time, the Supreme Court has allowed to stand on its shadow docket vacatures that were definitely, running, that clearly were, the government was arguing, were prohibited by 1252F, just like they're saying here. They did it in the MPP case, Biden v. Texas. There was a stay there. They did it again in U.S. v. Texas. And so I don't think, even if it does mean that what's left of 1252F1 is very, very little, which I don't think is true. I mean, ask the the immigration detainees, they don't think it's very little. But even if what's left is very little, it's on the other side is you really have to explain how to square the position with 50 years or something more of APA doctrine.
All right. Thank you. Let me hear from the government. It does appear that the U.S. Supreme Court has not addressed this question, has reserved this question, even though it's been tendered, that we have Fifth Circuit clearly distinguishing the, quote, less drastic remedy of vacator under 706 and a number of other courts. So that seems to be the main argument that the plaintiff is making. What's your response to that?
Yes, Your Honor, that's exactly what I was going to point out. This is not a settled question. The Supreme Court has reserved ruling on this issue. I would point you back to the text of the statute itself. Excuse me, the 1252F1. Excuse me. And that the language itself says no court shall have the jurisdiction or authority except the Supreme Court to enjoin or restrain the operation of the covered provisions. We do have a whole analysis of why 1254A is a covered provision. I believe plaintiffs have waived the argument on that point, and there's no disagreement that this is a covered provision under 1252F1. That statute tells us that this court
Although
cannot...
I will say, literally, if you look at the code section, it
Well,
doesn't line up.
Correct. The code cannot overcome the statutes at large. And if you look at the table of contents of IRA from 1996, you'll see 1254, which is 242, listed under Chapter 4 of the INA there. And we argue it's an error when the codifiers moved the statute of large into Title VIII.
So let's address the question about the ban, whether the ban on injunctions, quote unquote, applies.
Restrain is very clear, and that's what this postponement would do. Prior to Alaman Gonzalez, plaintiffs in this sphere didn't seek these postponements of decisions. But, and my friend across the aisle admitted that in, I think it is Texas v. United States, Judge Gorsuch did note that this was a clever workaround. He indicated that plaintiffs have just pivoted because of the interpretation in Alaman Gonzalez of 1252 F1. If you look at that language, Alaman defined restrain as to check, hold back, or prevent from some course of action, to inhibit, stop, or compel. And that's exactly what the postponement would do here. It would stop, it would inhibit the government from carrying out its actions, its lawful actions. To the argument of looking to Chen and whether or not a stay qualifies as an injunction, 1252 F1 has a carve out. It says you continue on other than with respect to the application of such provision to an individual alien against whom proceedings have been initiated. So that is how a stay of removal is not offensive to 1252 F1.
Sorry, say that again.
Sure. If you continue on in the language of 1252 F1, where we start, no court shall have jurisdiction, and you get to the end of part 4 of this subchapter, comma, other than with respect to the application of such provision to an individual alien against whom proceedings have been initiated. And the stays that counsel is talking about in Chen is a stay of immigration, a stay of removal issued by circuit courts.
That is,
those aren't
that's
prohibited.
an exception to the bar.
Correct. Those aren't prohibited by 1252 F1.
And so your argument is by sort of reverse implication that everything else would be covered, that this narrow exception states that the...
Correct, Your Honor. That the statute says when it doesn't apply. But it very clearly says, Congress has very clearly said, no authority to enjoin or restrain. And postponement is a restraint on the executive's action.
But no court has held that should be construed to apply to APA claims under 705 and 706 at this point.
Not yet. But it remains an open question. I mean, I think that the Fifth Circuit has held that. But as far as within this district and this circuit, no, it remains an open question.
Because Justice Gorsuch has stated one view, I think
Correct.
Justice
Judge
Sotomayor and Justice Barrett have said this question has not been ruled on yet, so it's...
Yes, Your Honor.
And the Ninth Circuit, Fifth Circuit's looked at it, but the Ninth Circuit has not adjudicated this precise question.
Not that I'm aware of. So it's for that reason that we argue that this court doesn't have the authority to issue the remedy that plaintiffs seek here.
What's your reaction to your opponent's point about there's a difference between vacator under 706 or postponement and an injunction, in part because an injunction runs against individuals who are subject to immediate contempt proceedings, whereas a vacator only operates on the agency action, and any contempt is another step removed, and therefore it is a less, quote, drastic remedy?
I think that falls into this clever workaround language. Functionally, they're operating the same. So just because you have to take one more step to enforce the postponement, it's still restraining the operation of the statute.
And what about the general presumption of reviewability, given the basic value of separation of powers in our government, that when you remove effective reviewability, that perhaps by way of relief, because you can't get damages, obviously, it essentially nullifies any kind of meaningful judicial review, that the presumption generally obtains against that, and statutes should be construed narrowly to the extent they purport to remove judicial review. How does that operate here?
I think here, right, there is that presumption unless Congress is clear, and I think that Congress has been clear in the language of both 1252 F1 and, as we'll discuss later, 1254A.
Is there anything in the congressional record on this particular section that sheds light on its application to APA actions?
Not that I'm aware of, Your Honor. I have not had time to go back and look at the congressional record of 1252 F1, of 242 F1.
All right. Well, let me give Mr. Arloston the chance to, if you have one more comment, and then I'd like to move on to the 1254B5A question.
Just very quickly, a few things about what Ms. Wong just said. The point about in Chen, Your Honor, is not about 1252 F1. In Chen is not construing 1252 F1. It's construing the next neighboring provision, 1252 F2. But the reason why I mention it is because it explains why a stay of removal is not an injunction. And 1252 F2 contains a different kind of bar, or just sets a very high standard for certain kinds of injunctions. And its explanation for why a stay of removal is not an injunction is equally applicable to the postponement that we're seeking here. And if you think about what a removal order is, it's an order from the Board of Immigration Appeals or an immigration judge saying this person can be deported. And the court is saying that, staying that, which is what happens when you have a deportation order that's being reviewed on a petition for review, or a removal order is being removed on reviewed on a petition for review. I think staying that is not an injunction. That's the holding of the Supreme Court in Chen. They say it's a stay, it's not an injunction. You know, what's the difference? And they say almost exactly the same argument that I'm making here today, and it's also, as I said, the reasoning of the Fifth Circuit. Second thing, I just want to be very clear about this. The Fifth Circuit ruled on our side of this question, and I think 5 district courts have ruled on our side of this question. No court in this country has ruled on their side of this question. And the last thing I'll say is, if Your Honor, we're actually going to kind of try to go down the road of applying the savings clause at the end of 1252 F1, which Ms. Wong referred to, other than with respect to individuals in proceedings, there are lots of Venezuelan TPS holders who are in proceedings, or who it's actually. Let me modify that. The phrase is against whom proceedings have been initiated, other than an individual alien against whom proceedings have been initiated. Our plaintiff MH, you were referring to them earlier, if I remember, the 3-year-old son and the 7-year-old. They have a check-in with ICE in May. There's another plaintiff, ER, so she's a 7th grade daughter, has a check-in with ICE in June. So those are people who definitely fit within the exception. There's more than 84,000 NTPS, the TPS Alliance Venezuelan members. There's obviously lots and lots of others. So it would be a mess to try to limit this court's ruling in some way via that exception. And I think much more straightforward from an administrative standpoint to postpone the effective date of the rule and preserve the rights just like every other normal APA case, Your Honor.
Well, that's sort of, I'm not sure which way that cuts, because if there are folks who are could get relief under the savings clause, I guess the comeback to that is that, well, then they should seek individualized release and not a wholesale invalidation of the Secretary of Nome's vacator.
Well, so to be clear, everybody loses their employment authorization. And there's many reasons why I think this provision doesn't apply that we didn't get into. One of the many is that once CPS expires, you lose your employment authorization. That applies to everyone.
That wouldn't be a proceeding brought under this part, such part.
I think, other than with respect to an individual against whom proceedings have been initiated, refers to removal proceedings. That's my understanding of what that term means. And then there's obviously a number of massive. So I would argue the harm that we're talking about, and the $3.5 billion for the April crowd and about $8 billion for everyone, that's triggered totally aside from whether or not people are put into removal proceedings. But the reason I raise this is to say that it doesn't make any sense that a provision like this, with an exception clause like that, would apply to this sort of programmatic policy where you're going to strip all these people of their employment authorization well in advance. But even if you reject our view, you'd have to split with the Fifth Circuit and all these district courts, and you'd have to explain why this is consistent with APA doctrine, which they still haven't done. All they've said is they think all the APA doctrine is wrong. But even if you went that road, we wouldn't be done. We would then, we'd come back here and say, there's thousands of people who, even under their interpretation, are entitled to relief and could be getting relief in this action, in this case. It doesn't say that you have to bring it in removal proceedings. It just says that you can't grant an injunction other than with respect to an individual against whom proceedings have been initiated. So, it's just all to say, they point to this as though it's a solution to the problem, but it just opens its own massive can of worms.
Well, I'm not sure they're saying it's a solution. They're saying it informs the interpretation of the rest of the statute.
Well,
you've got a savings clause that's been delimited, and therefore that would, I guess, argue for a broader interpretation of the front end of the statute.
I see. So then my answer to that would be the point I just made a minute ago, which is that there's a huge amount of harm caused by the termination, which cannot be addressed by waiting to raise challenges in removal proceedings. So it doesn't argue for a narrow interpretation on that basis. And the other thing I would say, Your Honor, is, as I understand it, their position is that the illegality of the TPS termination and vacatur cannot be raised in removal proceedings. That was their position last time, anyway, in Ramos, that we couldn't litigate these questions we're litigating now. Of course, the individual in removal proceedings couldn't compel the production of the administrative record, what we started the hearing with. So for both of those reasons, I would argue that the existence of the savings clause cannot be sufficient to resolve the problems that would be created by stripping.
In other words, there's no other forum to litigate this. It would preclude entirely judicial review, hence the rule of construction about narrow construction of such
Yes, Your Honor.
prohibitions.
Yes.
All right, we got to move on. Thank you to the other jurisdictional question, and whether that means judicial review, which is barred with respect to, quote, any determination with respect to the designation or termination or existence or extension of a designation of a foreign state. We did look at this question, and so did the Ninth Circuit panel in the now vacated Ramos decision in the Ninth Circuit. But the vacated decision, even the majority there, reached conclusion that the sweep of 1254B5 is limited, that determination, which is a key term here, pertains to review of the underlying considerations and reasoning employed by the Secretary in reaching her country-specific TPS determinations, determining whether or not conditions are so adverse that it's dangerous to send people back. Those are the kinds of things that are generally not reviewable, but that sort of procedural or collateral matters can be, and even under that framework, which is not binding here because that decision was vacated, but it's an indication of at least how three judges look at it. You look at such factors under McNary, as I understand it, as cited by the vacated Ramos decision. Is the review based on the merits of the individual situation, or is it a broad challenge? Is the administrative record for a single decision, does that have any relevance? Is that needed in the determination? And is the examination peculiarly within the agency's special expertise or integral part of its institutional competence? I mean, those are some factors that you looked at to determine whether it's that a determination or whether it's really collateral to that. And so here, if we look at the whole question of the vacator, not necessarily the termination, but just the vacator of the 2023 extension, That question seems to be a matter of statutory interpretation by each side, and whether or not the statutory framework of the TPS statute allows and has implicit authority or not. That doesn't sound like the kind of determination of country conditions that the Ramos case was referring to. And if you look to the reasons justifying the vacator, again, they were not so much based on analysis of country conditions, but really sort of whether what was done by Secretary Mayorkas before was so novel and perhaps inconsistent with the TPS statute, as was mentioned, and maybe, ultra virus or whatever, but again, didn't seem to be based on country conditions or anything akin to that. And so the record that you would look to, the agency expertise about evaluating country conditions and the safety of the return of folks doesn't seem to be at play here. So it seems to me, although this case is a slightly different question that's being raised than in Ramos, the framework, if we were to accept Ramos, at least the majority opinion, would suggest that 1254B5A would not bar, because this is not a, quote, determination within the meaning of that statute. So I'm going to let the government respond first, and then I'll give you a chance to respond, Mr. Arnold.
Your Honor, I think we need to go back to the text of the jurisdictional bar at 1254A-B5A. And the language is any determination of the Attorney General with respect to a designation or termination or extension. And that any has a broadening effect of the word determination. Since the last time we were here arguing this statute, the Supreme Court has weighed in again in the Patel case, Patel v. Garland, and has stated that any does have a broadening effect to the next word, to that determination. And so here, where the statute provides inherent authority to revisit decisions, the decision by Secretary Mayorkas had not even gone into effect. The Secretary came and was able to relook at that decision and determine that it didn't meet the statutory needs. She noted, if I find my language, she did note that she was relooking at it not only to untangle confusion and provide an opportunity for informed determinations, not only to untangle confusion, but to provide herself, she gave herself the space to make an informed determination regarding the TPS designation, and then clear guidance from the president that she was to look, the guidance being that she was to look at these designations and determine if they met the statutory requirements of the TPS statute. So I'm mixing arguments here, but the inherent authority to issue the vacatur is then swept up once she makes that decision to vacate the extension. That decision is then swept up under 1254A-B5A as any determination, as one of the determinations.
Well, but in your reading, if the bar of 1254 is so broad, we wouldn't even reach the question whether she had authority or not. We wouldn't even reach the question whether what she did was reasonable. There would just be no review. Whatever she did, no review, period.
I think that the Ninth Circuit in Ramos and yourself indicated that you could look at legal questions surrounding the interpretation of the statute. So
you could have judicial reviews to in construing the statute, for instance, and determining whether or not there was implicit authority or not?
Yes, Your Honor.
Okay.
But then once you look to determine that that the statute does provide that inherent authority, implicit authority, from there, the decision itself and the evidence and decision making by the Secretary, then you look at the language of the statute and note that, and it is a determination relating to, in this case, an extension.
Okay, so as I understand it, you would concede that looking at the statutory question, the first question of whether there was implicit authority under the statute, which is a matter of statutory interpretation, is within the realm of what this court can do. But if then I were to find that there was authority to do so, the way she exercised it, the reasons why she exercised it, that's where the bar on judicial review would apply. It's like a determination of a country condition.
It's correct. It falls within the same sort of analysis and what the secretary can look at, and that is open for the secretary.
Okay.
And it's not, I mean, it's not the first time that a vacatur has occurred. As we point out, Secretary Mayorkas did the same thing when he reconsidered and vacated the 4 terminations that were issued.
But it's the first time in 35 years that a vacator has been used to terminate an extension or a designation.
It's the first time that a vacator has been used to vacate an extension, correct? But that's a results-oriented analysis. If the statute provides authority, the statute provides authority for a secretary.
Well, it might, and I don't know how relevant it is that it's never been exercised until Secretary Mayorkas did it in the other direction, that is to vacate the termination, which effectively extended it, and now this time to vacate an extension, which effectively terminates it.
Correct.
Whether that agency practice for up until that point for 30-something years is informative of an interpretation, perhaps. But clearly until the last couple of years, no secretary has ever done that, right?
Correct, not until...
In either direction.
In either direction, Your Honor.
Well, let's talk about since everybody agrees that we should first determine, and it is appropriate for this court to determine whether or not there is this inherent authority to revisit. Again, I tell you, there's no direct cases on point. We're trying to discern from this statute.
No, Your Honor, not on this statute.
Yeah.
We do point to other cases that note if there's no rubric explaining how a decision can be reconsidered, then that authority is implicit in the statute. And I know that plaintiffs say, look, the statute lays this out at 60 days, and you have to look you can't revisit a decision if you're not within those 60 days, and this extension has already taken place. The 60-day language from the statute refers to the termination. It doesn't refer to anything else. So this was not a termination. This was a vacatur that allowed her to then follow the statute for the termination.
Well, let's look at that. So the statute does specify that once there's been a designation, it's supposed to be reviewed periodically, no later than 60 days before the end of that designated period. And if the Attorney General determines that the foreign state no longer meets the conditions for designation, then the Attorney General shall terminate the designation by publishing a notice, and the effective date of the termination is either 60 days after the date that notice is published, or if later the expiration of the most recent previous extension under the subparagraph. So in other words, you can't terminate, now I'm not talking about vacate, but you can't terminate midstream. You have to at least take it to the end of the period. And the periods are either 6 months, 12 months, or up to 18 months. That's within the discretion of the secretary in the first place for designating. But there is no ability to terminate prior to that. You can do the notice, give notice termination, even several months in advance, but the effective date can't be until at the earliest would be the expiration of that period, the original period.
That's correct, Your Honor.
So why isn't the Secretary Nome's vacator of the extension effectively, how's it any different from a termination? I mean, what's the difference?
The difference is that the vacator allowed her to then look at the country conditions in Venezuela and determine whether that second piece of the statute comes into play. Because you do have to look at the language of what Venezuela was designated under. And it was designated under the extraordinary and temporary conditions subsection. That subsection continues to say, if I can find it, if it's not contrary to the national interest. And so that's what Secretary Noem was doing. So the vacator gave her the space, I keep saying that, but it gave her the time to fit within the time frame that the statute permits.
But if you step back, the effect of the extension in 2023 was to give folks, both under the 2021 and the 2023 designations until, October or September, October of 26,
Yes.
correct? Mm-hmm. And so by vacating and then deciding she could terminate, some folks would not have the benefit. So it could shorten the period. So it is in effect an early termination. At the end of the day, that's what's happening.
Secretary Mayorkas made that determination in January, and Secretary Noem came in, and I think maybe 10 days later. So I think most individuals understood that TPS had an end date of April 7th if they were of April 2nd if they were under the 2023 redesignation. So the reliance interest there was the 10 days to 2 weeks between Secretary Mayorkas's extension and Secretary Noem coming in and vacating that decision.
Well, we'll talk about the reliance interests in a moment, but I'm just talking about as a matter of sort of statutory construction. If Secretary Noem could not have terminated earlier than the date of the extension date, how could she use the tool of vacator and then termination to essentially effectuate an earlier termination date? I mean, that's the upshot of all this.
Yes, Your Honor, because she used that periodic review language, and it says that the Secretary may periodically look at the conditions, look and determine whether or not that extension or that designation, those conditions still exist. And so in that periodic review, she determined that because the re-registration periods were overlapping, because she wanted to look at the conditions in Venezuela and determine whether or not the Venezuelan TPS designation, the redesignation met the standards of whether or not the extraordinary and temporary conditions still existed and if it was contrary to the national interest. That periodic review allowed her to go back and look at that extension. And then she was within the time frame to terminate.
It just seems to me it's still the same thing in substance. At the end of the day, it's an earlier termination that had otherwise been granted prior, and whether you call it a straight termination or a vacator followed by a relook and then a termination, the net effect is the same. And to use Justice Gorsuch's word, this looks like a clever workaround.
Well, and I go back to Mayorkas's own language that notes that the TPS statute does not limit the Secretary's inherent authority to reconsider any TPS-related determination, and upon reconsideration to change the determination.
Right. Well, that's one Secretary's interpretation of the statute. Maybe right, maybe wrong.
It's both Secretary's interpretation of the statute.
Well, there's two of them. On the other hand, we've got the statute. And even as a matter of statutory interpretation, putting aside whether this is a workaround or not, where a statute sets forth temporal expectations and time blocks and has specific markers, doesn't that suggest that it can't use whatever implicit authority to contravene that? That is, to do something. It is contemplated that there are clear time markers set forth in the TPS statute, and to take actions that effectively shorten the time seems like that's something that's not within the power of the agency to do once Congress had set forth temporal expectations and markers.
Well, I will note that the extension hadn't gone into effect. If you look at the language of the extension itself, it says this goes into effect on April 3rd. And so that is the decision that the Secretary is reviewing and reconsidering. The vacature had already gone into effect, but the extension had not. And so I go back to the statement that individuals were under the 2023 redesignation and extension. These individuals before, I'm getting all confused. The April 2nd deadline was one that individuals who had registered for TPS under 2023, under the 23 designation, they understood that to be the end of TPS. So then we have the 10-day period where Mayorkas extends, but we can't ignore the fact that a new administration is coming shortly thereafter. And so I think those 10 days to 2 weeks and the reliance interest there, and Secretary Noem recognizes that. That's overcome by what she finds to be the national interest concerns that she points out in her termination.
All right, let me hear the response to the argument that there was no violation of the statute, the time frame of the statute, since this was a vacator and the Secretary gave herself time before making a termination decision. So it's not synonymous, and also the argument that there was the extension by Secretary Mayorkas was not effective, and therefore, I guess the argument is there was no real termination.
Thank you. Good morning, Your Honor. Jessica Bunsel.
Yes.
To begin with the argument that because the vacatur was made within the 60-day period, it somehow didn't violate the fixed time terms of the TPS statute, Your Honor, that's incorrect. Under the statute, subsection B3B, that says that a termination cannot take effect earlier than 60 days after publication of the termination notice, or if later, the expiration of the most recent previous extension. And so when Secretary Mayorkas determined on January 17th that the conditions for Venezuela's TPS designation continued to be met, that determination under the statute triggered an extension. The extension flowed from that determination. And once that extension was on the books, this fixed time period set forth in the statute controls when a termination can take effect.
So which section do you cite for the proposition that once the determination by Secretary Mayorkas was made, that triggered the extension at that point?
Your Honor, in subsection B3C of the statute, provides that if the Attorney General does not determine that the foreign state no longer meets the conditions, and so on January 17th, Secretary Mayorkas determined that not only did it not no longer meet the conditions, he made an affirmative determination that conditions continued to be met. Under the statute, the period of designation of the foreign state is extended. If you look in the January 17th notice also, Your Honor, we disagree that that notice was not effective until April 3rd. The extension of work permits and lawful status began on April 3rd, but that January 17th notice says that TPS holders, for example, can show that notice to their employers with their EAD with that April 2nd expiration date as of January 17th. And the employer can take that to mean that their employment authorization is extended. It also opened registration to apply to extend your TPS through October 2nd, 2026 on January 17th. So that notice did take effect immediately, both under the statute and by its own terms, Your Honor.
Yes.
And then I guess that stands in contrast to Part B, which is termination that has time deadlines. There's a sort of breathing period, that is, you have to give at least 60 days notice before it's effective, or if later, the expiration of the previous extension period, whereas subsection C regarding the extension of a designation is simply is extended. It doesn't say 60 days later, etc.
That's correct, Your Honor. The extension is effective immediately. The other point I'll make is that the TPS holders who are covered under the 2023 extension, my friend opposing counsel said that they knew their TPS would end on April 2nd. That's not correct. They knew that a new decision was required within 60 days before April 2nd, and they knew what conditions in Venezuela were, and so they knew a new decision would be coming, but they weren't anticipating. There wasn't a termination of Venezuela that was set to take effect at that time.
Right. What about the other argument that there was not a termination, that this was a vacator?
First, Your Honor, under Gorbach, the en banc Ninth Circuit decision in Gorbach and China Unicom just a few months ago, as Your Honor stated, where a statute provides a specific process to alter an authorization, here the designation, that negates an assertion of
I'm sorry, say it again.
Where a statute provides a specific process to alter the designation, that negates an assertion of implied agency authority. I just also mentioned that, as Your Honor mentioned, neither of those cases discuss the TPS statute, but Gorbach does address one other statutory provision the government points to, which is 8 U.S.C. 1103A, the sort of broad enabling statute that sets forth the Secretary's powers and responsibilities. And they say that that is not a source of implicit reconsideration authority, and that because in Gorbach the question was whether the Attorney General had authority to denaturalize a person where she had evidence that the naturalization was based on a fraud or material misrepresentation, and the court said no, because the statute sets forth a process for denaturalization, and that exhausts the field. Similarly here, Your Honor, the TPS statute has a process for altering a TPS designation, and that's inconsistent. That process is inconsistent with an assertion of implicit authority to reconsider. And the fixed time period also is another
When you
separate
say
factor.
the process, that's the process for the periodic review?
Yes, Your Honor, the process in subsection B3 of the statute, the periodic review. It says when the decision has to be made, it requires consultation, it says how and when the decision has to be published, it says the bases, the permissible bases for a decision, and it says what the options are, and the options are to extend or to terminate, Your Honor. There is no vacatur. Under Gorbach and China Unicom, that process exhausts the field, and that process negates an assertion of implied agency reconsideration authority. We also cite, Your Honor, a D.C. Circuit case that involves a similar statutory scheme from 2023. It's NRDC versus Reagan. That was a case that addressed whether the EPA had authority to reconsider its determination that a certain contaminant in drinking water should be regulated. It's similar because the EPA there had a lot of discretion at the outset to determine whether regulation was appropriate, but once it made that determination, it triggered certain things under the statute. And so the court held to allow the EPA to reconsider its determination, just wipe it from the books, contravene the statute, because under the statute, the determination triggered, certain things flowed from that. The same with the TPS statute, Your Honor. Secretary Mayorkas's determination that conditions for the designation continued to be met triggered an extension, and under the statute, TPS could not be terminated before the expiration date for that extension. So to allow the vacatur here would contravene both those protections in the statute.
And what's your response to the argument? We're going to need to take a break here in a moment because the court reporter's been going at it. But what's your response to the need, if an emergency arises, a national emergency arises, that the government and the Secretary needs flexibility, and that's why one should imply some additional authority beyond that that's prescribed in the TPS statute? What's your response to that?
A few things, Your Honor. One is that Congress has provided a means in the TPS statute for the Secretary to address national security issues. And it is not to vacate a TPS extension for 600,000 people. Under subsection C2B, if the Secretary determines there are reasonable grounds to regard an individual as a danger to the security of the United States, that individual is not eligible for TPS, and that individual's TPS may be withdrawn. that's the mechanism Congress has provided to the Secretary. The second point I would say, Your Honor, is that if you look at the vacatur and the government's arguments in the brief, the vacatur, as you noted, is based on alleged problems with the filing process. Vacatur is not based on national security issues. And the last point I'd make, Your Honor, is that China Unicom, which sets forth this rule that where the statute has a specific procedure that exhausts the field, that's a case where the agency was asserting reconsideration authority based on national security grounds. And so there's not a different rule in that context. Even if the agency is asserting national security or some other important interest, they still have to follow the law.
All right, let me give you a brief chance, and then we're going to take a break, and I want to continue after we give the court reporter a chance.
Sure, Your Honor. I do want to go back and note that the extension itself explicitly says that it doesn't go into effect until April 3rd, 2025. So I understand plaintiffs would like for it to run into effect immediately, but the language itself in the FRN explicitly gives the effective date. And just because it allows people to re-register, that makes sense as a practical matter so that there would be no break in their employment authorization documents.
What does effective date mean? Does that mean that because there was already a designation extension that this
Correct.
becomes, it doesn't mean that it doesn't have any operative effect?
It has operative effect, but it's not going to do anything until April 3rd. People can re-register and they can have their employment documents teed up so that they can continue working, but that extension, it doesn't go into effect until April 3rd.
So you're saying that at the very least, the Secretary has the ability to vacate an action if it's not in effect at the time of the vacatur?
Yes, Your Honor.
And is there a case law that draws that distinction, that keys it to the effective date?
Not that I'm aware of, but that is also what Secretary Mayorkas relied upon when he vacated the termination decisions. I would also point out that it is contrary to the statute to say that a secretary cannot come in and look and determine if there's a national interest concern.
Well, it can, but it does so in the process of designating, whether or not a TPS status is warranted under subsection C.
Well, and different administrations are permitted to come in with different goals and different policies as long as they're within the confines of the statute. And here, the statute provides a periodic review. So the idea that the secretary would have to wait a year and a half before she could make what she feels is a concerning decision against the national interest of the United States is contrary to what the language of the statute itself says.
Well, I'm not so sure about that. The language of the statute says, even considering where TPS status is granted in part because of concerns about national interests. By the way, it says national interests. I'm not sure how that's different from national security, but national interests of the United States.
Yes.
It still says that to terminate, you've got to follow 3B. And there was no exception to say, well, if the designation is made under B1C in the national interests and that can be advanced or something. There's nothing that says that.
I'm sorry, could you say that again?
Nothing in the statute allows an advancement of the termination right where the designation is based on B1C, national interests. It makes no distinction. It just says you've got to do it, during these periodic reviews, et cetera, et cetera.
Correct, Your Honor. That's why we argued that it's inherent in the statute. It's not explicit in the statute.
All right. When we come back, I do want to address the reasons for the vacator and the question of whether there's a review of that, assuming that that there is authority to vacate. I think the secondary argument is that it was still wrongful to do it. Obviously, if I were to find, as a matter of statutory construction, that there was no power, we don't need to reach that question. And then I do want to address the equal protection matter. So we'll take a 15-minute break. Our reporter's been going at it. Thank you.
Court is in recess.